are muted when you're not speaking. If you have any questions, please hold them and we'll have a period for questions for the public. However, if you feel free to take advantage of the chat function to send questions in, and then we will definitely address those during the question and answer period of the meeting. So thanks for that. So today we are here for the review and vote on the application form for the Clemency Board. The Clemency Board met in subcommittee on January 14th, 2022 to review the remainder of the Clemency Board application. We will now review the application based on edits that were made during that subcommittee meeting. Christina Sacco from the Office of the General Counsel, our board staff, will now guide the review of the application. Christina, I'm going to ask that you answer any questions concerning the application that the board might have. And but first, if you could address questions from the board and then questions from the public, that would be best. Okay.
Sure. Thank you, Patrick. Good morning and welcome, everyone. Good to see you all again. So I'm going to do our same process as we comb through the application. What I'll do is as we go through each question, I'll open the floor for questions from the board and then questions from the public. And so just give me a moment to share my screen. Can everyone see the application in front of you? Great. Awesome. Right. So as you're all familiar, the initial part of the application is more of an instructional page. When the subcommittee met last week, one of the things we worked on was bolstering this aspect of the application, and particularly the bolded language. And what it states is that to be granted clemency, you must file an application with the U.S. Department of Justice, Office of the Pardon Attorney. You can access that application here, so we've attached a link to the application. Because DC is not a state and the mayor is not a governor, the Clemency Board cannot grant clemency. It can recommend that the President of the United States grant clemency. If the Clemency Board decides to write a letter recommending clemency for you, it will send the letter of recommendation to the President of the United States for consideration when granting clemency, and a copy to the DOJ Pardon Office. Part of this was just to kind of explain, I think one of the things we were highlighting throughout is that we want to be able to educate the public about what they're receiving from the Clemency Board, and that it's not a body that can grant clemency. And I just wanted to pause there to see if any board members had any questions, issues with that. If not, we can move forward. Okay, great. So one of the things we did add in review is just to kind of clarify and add definitions here. And that was to explain what a pardon and what a commutation is. In review of what a commutation is, one thing we specify that if you are not in prison for a commutation, and that's highlighted here, you can only apply, if you are in prison now, I'm sorry, you can only apply for a commutation. So just some basic simplicity language, that's been our priority in explaining the difference between a pardon and a commutation. So they can understand the tracks that they're available under a clemency application. Any questions there? Right. The next category goes with how you submit an application with the Clemency Board. And no changes were done here. This is just part of the review. But we wanted to highlight here for the board that, again, the application is available online. It would be added to the Clemency Board's website, and applicants can submit an application online. They can also apply by downloading the application form. And one of the ways, you can fill it in, it would be a fillable PDF that can be downloaded or filled in by hand. So they can download it, print it, including the releases that we will need. And they may be able to email the completed form and releases to clemency@dc.gov. And the third option is just downloading it, filling it, including the releases, and then mailing it to us. So we have 3 options available to apply. Mailing address for the Clemency Board. And that is the instructional page. Any questions and concerns before we go on to the questions? All right. Right, so application for a letter of recommendation. One of the things we highlighted is that there needs to be a complete application. And if you can see in the beginning in the preamble of the application questions, we highlight in bold that if we are unable to contact you or your application remains incomplete, your application may be closed after 6 months from the date you submitted your application. And that tracks with the regulation language, which we went into, that an application needs to be complete. And we certainly would give those 2 notices that we have added into the regulation and bring an application to completion would be our best efforts for the board. But I just wanted to highlight that in the instructional page. Okay, so eligibility questions. So the application opens up, and the way it would look, the green bracketed language is an instructional language that we would highlight to our Office of Technology that how to structure the questioning. So that is not what the applicant would see. Since we are having it on, we're trying to try different formats of how to apply online, whether it's just a window where each question would pop up or a whole form. So ignore the green instructional language. That is for the Office of Technology. So the first questions ask, have you submitted an application for a pardon or commutation with the U.S. Department of Justice? If you're unsure, you can check the status of your DOJ application here. So we provide a link where they can look up their application by their name. If no, what we state is, please keep in mind that the Clemency Board does not have the authority to grant clemency. The power to grant clemency ultimately rests with the President. This application with the Clemency Board is not an application for clemency. It should say it is. It is an application for a letter of recommendation. The Clemency Board can only recommend clemency to the President of the United States. To be considered for clemency, you must submit an application for clemency with DOJ pardon. The DOJ pardon application for clemency can be accessed here. So throughout the application, we've been highlighting resources that they could link to be able to bolster their resources to possibly seeking clemency. Any questions with question 1? Okay. Question 2, pretty self-explanatory. When did you apply for clemency with DOJ pardon? Part of it is just to help us find the application. So if they have the submittal date, or to let us know if they don't remember. Question 3 asks, for what offenses did you apply for clemency with DOJ pardon? Describe the offenses. Please be detailed. For example, I applied for clemency for an assault that I received on March 3rd, 1990 in Washington, D.C. Part of that is just to be able to give a little bit of a guide of what type of information we were looking for.
Christina, I have a few minor comments in this.
Yeah.
Is there some feedback for me?
Sure.
Okay. There were just a few typos that I was just going to maybe send you separately, if that's okay, instead of taking up everyone's time on purely non-substantive things. But this,
Sure.
I'll just bring some very small things up here. We had changed some of the wording for an assault that I was convicted of instead of received. I think that mirrors the wording in a below question.
Okay, thank you, Ilana. Other board members, any concerns?
I had a couple spots, and I can send you these separately too, where I feel like we're using clemency, pardon, and commutation not sort of inconsistently, and that we should put, there's some questions where all three of those should be just spelled out, or clemency and pardon
Okay.
rather than commutation.
Okay.
And I can hide, yeah, it's just having that consistency as we go through so that people aren't confused.
That would be great. Thank you, Katya, if you can
Sure.
send those to me. Anyone else? Okay. So question 4 states, if they do not have a clemency board application, where we ask for, if no, please tell us what, not a clemency board application, I'm sorry. If they do not have an application with DOJ pardon, please tell us what sentence the judge imposed. So part of this is with respect to question 3 here. Actually, this should not say if no, this should just say, please tell us what sentence the judge imposed when you were originally convicted for the offense you listed in question 3. And part of that is to understand the sentencing guidelines if we're dealing with a reduction of sentence, and try to delve deeper more about what an applicant knows about their sentencing. Any concerns with the phrasing of that question?
That is fine. So just confirming, clarifying, question 4 applies to people who have submitted a pardon, an application with pardon, and people who have not.
So it doesn't track. So this is for everybody. This is a question for everyone, yes. Five asks, for which of the following are you seeking a letter of recommendation from the district's clemency board? Select a pardon or a commutation, which we've defined above. Any questions or concerns there? Okay. 6 is specifically for pardons, and it goes into the statutory language that, did you go to prison for the offense that you were pardoned, that you want pardoned? Yet, if yes, has it been 5 years since you were released? If it has, then they continue on. If it hasn't, their application would stop there, and a note would pop up and say you're not eligible to apply at this time. Once it's been 5 years from the date you were released, you may apply for a letter of recommendation from the clemency board. If it has been 5 years since they've been released, they go to question 7. But if it's no, the next question would ask, has it been 5 years since you were convicted? So there are 2 requirements for pardon. Has it been 5 years since you were released, or has it been 5 years since you were convicted? If yes, they continue on. If no, same note would pop up. You're not eligible at this time. Once it's been 5 years from the date you were convicted, you may apply for a letter of recommendation from the clemency board. Any questions with respect to question 6? Okay. Question 7 asks, for what offense are you seeking a letter of recommendation for clemency from the board? Please be detailed. So we provide a guided example. For example, I'm seeking clemency for an assault that I was convicted of on March 3rd, 1990 in Washington, D.C. Any questions with 7? Question 8 asks, are you currently challenging your conviction or seeking review of your sentence through appeal or other court proceedings? If no, continue to the next question. If yes, it states you're not eligible to apply for a letter of recommendation at this time. The Clemency Board cannot write a letter recommending clemency until you've concluded all judicial challenges to your conviction and or sentence. You may reapply for that letter of recommendation at that time. Any questions with respect to question 8? All right. Question 9 reinforces that. It goes into asking about whether they've exhausted their judicial or administrative remedy. So have you exhausted all judicial or administrative relief available to you to challenge your conviction or sentence, meaning your sentence is final and you have no other judicial or administrative ways of challenging it or your conviction. This can include relief such as motions for compassionate release or relief under the Incarceration Reduction Act. If yes, please tell us more about the relief you have sought in the past. If no, please note that the Clemency Act requires you to exhaust all judicial and administrative remedies. Here are links to some, not all, judicial administrative remedies that may be available to you to challenge your conviction or sentence, and their citations to the DC Code for IRA and motion for compassionate release.
In the wording of the question for number 9, I don't know if meaning your sentence is final. I think that we should take out the sentence is final. I think that's not quite accurate. So I think just taking out the words your sentence is final, and so meaning you have no other judicial or administrative ways of challenging perhaps your sentence or your conviction. Because a sentence would be final, but you could still file a later motion for relief.
Okay. Any questions or concerns from other board members?
Just to administrative ways of challenging either your sentence or your conviction, perhaps, to clarify.
All right. Great. Thank you. Moving on to 10. 10 states, do you have any pending criminal cases in the District of Columbia or in any other jurisdiction, pending criminal cases or cases that are currently not been tried in court and are awaiting we could say a decision instead of final, and tracking with what you stated, Ramona, a decision by a judge or a jury. Part of it is just to explain what pending means. If there is a pending case, please tell us more about any pending charges or fines. Please indicate what the charge is for, the date of the charge, and the case number. If no, continue on.
I'll defer to some of my defense attorney colleagues here, but we might want to be specific in what we're asking for with pending cases so that there's no real narrative and discussion of the underlying facts inadvertently. And really just stick to, the charge, the date of the charge and case number instead of a broader question.
That's a good idea.
So what you're stating is remove this and tell us more about the charge or the fines, but instead indicate what the charge is for and the date of the charge and the case number.
Yeah, just any specific information, just please indicate what the charge is for, the date of the charge and case number. I don't know if there's anything else you want to capture, but just not an open-ended narrative.
You could write, please state only, underline only, the case number. Why don't we just ask for the case number?
Or the jurisdiction too
Even-
might be helpful.
Yeah, and jurisdiction, yeah. Because even with charges, there's some confusion there sometimes.
And the jurisdiction it involves? Case.
And just jurisdiction.
Okay.
Then we could put parentheses, state or DC. I guess it could be federal court too.
So state, district,
I'm
state.
wondering
or
if
federal.
jurisdiction is a common enough usage of that for people to understand. Case number and jurisdiction, maybe it's fine.
Okay.
We say, please provide only, underline only the case number and jurisdiction.
Okay. Any other concerns? Great. So with question 11, it states, do you have any other criminal convictions? If yes, please tell us more about any other criminal convictions you may have. Please indicate what the conviction is for, the date of the conviction, and the case number. If no, continue on.
Maybe just, do you have any criminal convictions other than the convictions for which you're seeking clemency?
And so, right, part of the reason why I kept it so broad and open-ended is because we want to know if they just have, period, any other criminal convictions, and I just wanted to make it a much more simpler phrase than be more specific. So I wanted to make it more simple than add all these conditions to it.
That's fine. I don't have strong feelings.
All right. And question 12 asks, are you under any form of community supervision, including parole, supervised release, or probation? If yes, please provide more information. If no, continue to question 13. Any concerns with the phrasing in 12?
I was just wondering whether provide more information. Again, that's a really open-ended thing. What do we really need to know from that?
So originally we had, please tell us more about the conditions of your supervision, parole, supervised release. It was more detailed, but we kept it open-ended because they're different structures for supervised release. But again, happy to narrow it down if sees fit.
I think that's fine for the population we're giving it to. I think they'll do well with that. The way you have it set on it. At least that's my opinion.
Okay. All right. And question 13 asks, have you filed a lawsuit or been sued in a civil case, whether the case concluded or is still pending? Can you provide a description of what a civil case is? Civil cases are non-criminal lawsuits, which usually involve issues such as domestic violence, civil protection orders, breach of contract, landlord-tenant disputes, negligence, divorce negligence, and copyright violations, etc. If yes, please tell us more about any pending civil cases involving you. Please indicate what the civil case is about, the date of case filing and case number. Now, please continue the next portion of the application. Any questions? And I think the only thing I did notice here is because we asked for cases that are concluded or pending. I would just say, please tell us more about any civil cases instead of just pending involving. And next portion of the application is the contact information. So we ask for full name, email address if they have one, a phone number where we can reach them, a mailing address, date of birth, social security number if they have one, DC number if it's accessible, a BOP number, a PDID number, name of facility in which they're confined at, provide us your projected release date if they know, and then how may we contact them? We provide a notice that BOP communications are not privileged, and so they're aware that they're monitored by BOP, such as mail, email. And then we ask for, as we did before, how they prefer to be contacted, whether it's by phone, email, or mail. And then we ask whether they have an attorney, family member, or another person. Whether did an attorney, family member, or another person assist you with this application? If yes, and we contact them and they provide the name, relationship, and phone number. And then we ask whether they want that individual to be notified of a hearing that we may schedule with the Clemency Board, yes or no. And the following question asks, do you give the Clemency Board permission to share information about your application with the person listed? If yes or no. And of course, we have a no question that they're representing themselves.
So I think there's a you instead of your on that second one. I'm not sure if I'm having difficulty hearing you, Christina. Yeah, it's definitely muted in some weird way. Not the usual mute on or off.
Sounds kind of staticky.
So we can see your screen again, but your voice is still coming through like it's a robotic kind of tone. Same. Yeah, I'm wondering if we should just proceed with the application, and you're not the one doing the run through.
Right.
Yeah, I really can't understand what you're saying. So I can just pick up where you are right now on the screen, and we'll just do the quick run through with everybody. Okay. So I think everything till now we're clear about. Please check with the priority groups if you have any which belong 50 years or older, have served at least 15 years in prison. That's one category. I was diagnosed with a terminal illness by a medical professional, and we asked some clarifying questions about that. Have you applied for compassionate release? If yes, please tell us when. If no, here's how you do it. Applicants are required, again, we do that reminder again, you request a requirement to exhaust all judicial or administrative relief opportunities before our process. Back to the check boxes, my offense of conviction was decriminalized, or the sentencing scheme for my offense for which I was convicted was changed to provide for less severe penalties. I think for my offenses, it should say for offenses for which you can take out that my. Yep. If your sentence has been changed in any way, please tell us more about those changes. The opportunity to fill in the blank there. Anybody have any questions or comments about that part? Okay, seeing none, we'll keep going. Okay, so here is an issue. I am back to one of the priority group things. I am claiming actual innocence for the crime of which I was convicted or other. So I do think that there is some conversation about innocence, and I would leave this to maybe some of the folks who are on the subcommittee meeting about the issue of innocence, and just if we could have a brief conversation about what that issue is, it would be helpful. And I'm looking to the lawyers.
I know I've raised this before, just my concern about this being a forum to litigate actual innocence. I just don't think that this is the right forum for that. There are, avenues through the judicial system to litigate that, and I'm just concerned that a lot of the issues that could come up just wouldn't be most appropriately addressed through this litigation or through this board, and also given USAO's limited involvement, we wouldn't really be able to weigh in on this question, which in our perspective could be relevant on this issue to some. I recognize that people who are claiming they're actually innocent can apply, but I just have concerns about this being a forum to litigate those issues.
This is Felisa. This is like an issue that keeps popping up with the board. I mean, it's something that we just have discussed before. I mean, even in the statute, it says we, like, as a board, we must address these things. So I think it's something that we have to make mention of it on this application. It has to go somewhere. Now, we can have a debate on whether or not this is a proper, what our role will be in discussing actual innocence, but it's something even under the statute that we are obligated to address. So we just can't ignore it.
So just if you could refresh my memory, this is actual innocence is part of the statute.
My reading of the statute is it just says that the board shall consider both cases of actual innocence and cases of those who are remorseful and can show they've been rehabilitated. It doesn't set it forth as a priority group, and it doesn't really mandate that the board litigate those. It just says that the board could consider both, remorse cases and actual innocence cases.
Yeah, consideration being the operative word. So it's something that we can ignore. Now we can go into details about how we're going to address it, but maybe later on. But I think that's not an issue we just can ignore. We can maybe put a pin in it, but it's something that we need to address.
Yeah, this is Andy. I agree with that as well, and I think we just have to be careful not to get into the weeds. But I think we need to know what's the basis on which the applicant is making his or her claim for clemency, and if it's actual innocence, I don't think we can avoid that.
So this is Emily. I don't disagree with anything anybody's saying. I have a more technical concern, which is I think actual innocence is a term of art that lawyers know what it means. And I don't think it's going to be obvious to the person applying what it means. And there might be people who are applying for clemency because they think, having nothing to do with a claim of actual innocence, but might also want us to know, by the way, I didn't do this, right? And so that is different than seeking clemency on the basis of actual innocence. I think it's a more technical and larger conversation about whether or not the Clemency Board statute requires us to, right? I could see two different interpretations of it. One is the fact that somebody is claiming innocence does not negate our ability to otherwise consider clemency. Another way to interpret it potentially is that we are to determine whether or not we think the person is actually innocent. I think that's much more complicated, and I tend to agree with Ilana that we don't have the ability to do that. But no matter how we add this or consider this, I think we should think some more about how this is phrased on the application, because I am worried that it's going to cause people to include information that we would not want them to include without consulting with an attorney.
Would you have any suggested language on that, Emily? Or I appreciate the clarity you just brought to the conversation.
So if we are interpreting the Clemency Board statutes to mean the fact that somebody is actually claiming innocence does not negate our ability to consider them for clemency, then we don't need a question about it, because, right, what the purpose of the statute would be is that an actual innocence claim that's currently pending or maybe being considered is irrelevant to whether or not we can consider clemency. If we are saying we are allowed to consider whether or not somebody is actually innocent and granting clemency on that basis, that would require an entirely different application, in my view. Maybe there's a third interpretation of the statute I'm not considering. Be very interested in other folks on this board's views on that.
I agree with Emily's assessment. And also, this question is whether it's a priority group. This isn't whether the board considers it. This is just whether they're a priority group. So this is kind of a separate discussion than whether the board considers it at all, the placement here.
This is Felisa. So maybe I can understand what Ilana and Emily are saying. Well, it's not actual innocence is not a priority group, but I believe that it should be placed somewhere on the application. Now we can like in other drafts of this application that there was language placed in there. If you're somewhere on this application, if you are claiming actual innocence, you must consult, you need to consult with an attorney. Somewhere to those words or something, but like maybe a separate question out, like if you are, or at the top, if you are considering, top of the application, if you are considering applying under actual innocence, you need to consult an attorney. This might, maybe this application is not, pertaining to that particular issue, but that issue must be something that the applicant consults with an attorney.
So
sorry.
Go
Go
ahead,
ahead, Emily. I think that makes sense. The idea that that any claim of actual innocence should go through an attorney. I was just looking at this statute, and it just says that the board consider cases of actual innocence and cases of those who are remorseful and can show that they have been rehabilitated. So it doesn't establish it as a requirement or as a priority group. And I am concerned that it's just the claim should be fully developed and it cannot really be fully developed on this application without the assistance of a lawyer and without just like kind of more framing, potentially with other information that the individual wants to introduce. So this isn't conducive to that person putting their claim of innocence in the sort of with the most compelling facts forward.
Yeah, I agree with you completely, Katya. And what I was going to say is, right, this might require a whole different conversation that I think is more than this group can get into in terms of a legal interpretation of the statute. The way I read this is that, one of the things that comes up for people, both in parole and in clemency issues generally, is that the person is asked whether or not they're remorseful, and it puts them in this bind about being able to actually be considered for parole if they didn't commit the crime they were convicted of, right? And so the way I interpret this is that the council was trying to take that off of the table and permitted us to continue to consider somebody for clemency, even if the person was saying they weren't convicted of the crime they committed, as opposed to having us determine whether or not the person's actually innocent. I tend to agree with Ilana that we don't have the capacity to determine whether or not somebody's actually innocent. So that is my 2 cents on this. And if that is the case, I continue to think that it doesn't require us asking the person if they're actually innocent. It just allows us to consider their application, even if they're saying, I didn't commit this crime. And I'm really worried about somebody writing on here exactly what Katya said, something that could hurt a legitimate claim for actual innocence.
A point in response to that and a question. I think there's 2 different issues. One is actual innocence a basis of your application? And that does not necessarily mean that we have to litigate whether or not they are actually innocent. So I think of it in 2 different ways. But does anybody know how the Justice Department handles this issue? Is it on their application? What do they do when someone says I'm innocent? And that's why I want clemency. Anybody? Christina, do you happen to know?
So that's a great question, Andy. We haven't had this conversation with the Justice Department, partly because we wanted to have it first with the Clemency Board and see how we can deal with it. But more particularly, I think what has been raised is that we, as a board, cannot determine whether someone's innocence claim is valid or not, because we don't have the ability to try or litigate a case the way a court would. I'm certainly happy to have that conversation with DOJ Pardon, but I guess the reason why this was brought up in discussion with our priority group subcommittee was the issue of someone saying I'm innocent, and then as you see our essay question, it goes into remorse and rehabilitation, which is what factors we look into when we consider clemency. But if someone's claiming actual innocence, they don't really have anything to be remorseful or rehabilitated from. So it creates legal issues there for us. So I think ultimately, my recommendation is that actual innocence should not be under the umbrella of the Clemency Board. And we can certainly look further into it with counsel and looking into the legislative history and intent for this, just because of the legal issues. And I wanted to highlight something Felisa said, was that if we ask this question, we would tell them that they would need to seek counsel. Ultimately, that puts us in an advocating position, and the Clemency Board is a neutral body, and hence why my recommendation is to not even ask for actual innocence cases, because we don't want to receive information from applicants that could jeopardize their case later on down the road.
Can I ask, what is the practical impact of removing this question? Are we in violation of the regulation? Are we missing some major data point? What's the actual, if we don't ask this question, what's the impact of that?
Legally, it's not mandated by the statute. It's that we shall consider it as an area of interest. However, I think ultimately this is something to have a larger conversation with Chairman Allen's office, because they are the writers of this statute, to kind of understand their thinking of what was its intent. But I really think that this would ultimately be something that the board cannot look at without it being something that is tried in court before a jury, where facts can be challenged, witnesses can be called, You know, DNA evidence can be evaluated and corroborated. And I think that is way beyond the board's ability.
I think Emily's interpretation of the statute is correct, that it's not, that what the board is trying to do is not say only people who have admitted the conduct and are remorseful for the conduct can be considered. It is really, it's sort of both individuals who are in both situations. And there are going to be lots of individuals whose files we get where there will be evidence that they filed various motions on actual innocence grounds. And so I think what the statute is saying is that individuals who have filed those things are not disqualified. And that everyone should be considered regardless of where they are in that prior process. And so I don't, if we view the statute as saying that, then there is no problem with omitting that question because you're not asking for information about it. It's just what we do if we find evidence in the files that there have been those claims.
Well, I think this puts an honest defendant in a tough spot. If they honestly say, I'm not remorseful and I'm not rehabilitated, yet they don't get an opportunity on our form to say why they're asking for clemency, which is that I didn't do it. I don't think we should put ourselves in a position where we have to figure out from their whole file, which we may or may not have, what their claims were over the past 5 years, most of which, you know, the very few actual innocence claims happen after 5 years. Occasionally they do, but it's a rarity. And I disagree with the interpretation of the statute. When the legislature says you shall consider it, then you shall consider it, not may, you shall. And I agree with Felicia, it doesn't necessarily have to be here, implying that it's a priority area. But I think the application has to reflect the basis on which the clemency request is being made. And if that's actual innocence, we need to know that. Now, if there's a concern about them then telling us facts that conflict with what facts they're saying in litigation, then let's say that. Don't tell us anything about the facts or why. Just tell us whether you're making a claim on the basis of actual innocence or not. That's what I think, for what it's worth.
I don't think our interpretation is inconsistent with what you're saying, or I should say my interpretation, right? Like, I agree that we are required to consider cases of actual innocence. I just don't think we're required to determine if the person is actually innocent, right? We're required to include in our consideration of clemency both those who are remorseful and those who are saying they are innocent. We may grant clemency on a basis other than the fact that they are innocent, i.e. that they, right, have been in prison for a very long time and have demonstrated themselves to not be a danger, et cetera, you know, speaking off the top of my head here. So I agree that we are required to consider them. I think that is different than being required to adjudicate whether or not they are actually innocent. But all that being said, that your proposed solution makes sense to me, right, to give them an opportunity to explain a basis without having to express remorse. And so I forget the wording you actually used, but I would be, I think, on board with a solution like that, which is something like, you know, if you are, don't tell us any of the facts basically about why you think you're actually innocent. Just let us know if that's your views of what one of the reasons you should be granted clemency. You didn't commit the crime.
Yeah, and Alana, I don't want you or anyone to think that I'm suggesting we litigate and determine actual innocence as a basis of granting clemency. I just think we should know if that is the basis upon which the applicant is applying. So I totally agree with everything you said.
Yeah, and I don't think it would be inappropriate to include a reference to this in the general narrative section. And I think that could be the place for it. You know, like, why do you want clemency, remorse, actual innocence? And it could be there in the general section, just as kind of the list of factors if we wanted it to be somewhere. A few other notes. Andy, you just asked about the pardon petitions, and I just looked those up. And I think both the pardon and commutation petitions or applications from the pardon office just say, state your reasons for seeking commutation, state your reasons for seeking a pardon, kind of have an open-ended narrative. You know, I think if somebody did believe they were innocent, probably that would fall into the open-ended narrative at some point. But my last point on this is there are judicial avenues available, as we've kind of talked about, for litigating claims of actual innocence. And because you have to exhaust judicial relief before filing for clemency, presumably if you had a claim of actual innocence, you would have had to litigate that in a judicial setting before, you know, presenting your application for clemency to the clemency board. So, you know, I think that there could be some record developed from the litigation that you would have necessarily had to exhaust before filing a clemency petition on that basis.
Yeah, this is Emily. That all makes sense to me. I would just, as a minor point, would stay away from using the term actual innocence because I don't think anybody but lawyers knows what that means. So
You're right. Agreed.
Yeah, that makes sense to me too. And thank you for looking up DOJ's application.
So am I hearing that if we go back up to the top of this application and as one of the general categories similar to pardon, commutation, actual innocence as sort of a qualifier at the very beginning, and we put the same sort of things with actual innocence about in the notations about have you fully adjudicated this? Is that sufficient?
I wasn't trying to open a can of worms here. If I did, my apologies. I was just trying to kind of note that this could fall in the general narrative section where we kind of say why
Yeah,
we believe you're appropriate for clemency.
I want us to address this issue that in the full robust way that board members believe we are responsible to do. So opening a can of worms is fine. I prefer that we actually do, this is our job. So
If I may make a recommendation, hopefully
sure.
my sound is clear, but I think I agree. I think we can certainly ask that. What is innocence a basis of your application today? And then please don't tell us anything more. And I think in the essay portion, which we haven't gotten to, I think there needs to be in big bold letters, you know, please don't tell us anything about your actual innocence claim. And from move forward from there, and maybe they can just tell us like what case number it is and what it involves. And
So-
keep.
So what's the relevance to us if you just say, are you saying you're actually innocent? Don't tell us anything, talk to a lawyer. Like where does that get the board?
I guess that goes into, you know, what does considering an actual innocence case mean, right? And what does that look like, and what we as a board can offer an applicant that is claiming actual innocence, right? Because ultimately our product is a letter of recommendation for clemency, right? And so in these cases, if we do find someone that has made all these motions for actual innocence, how can we as a board help them? Are we providing them a letter of recommendation for clemency? That goes up to the President of the United States. And I guess that's ultimately why I'm raising this to the board is how do we recommend that the president grant this case because this person has been claiming that they're innocent, but we can't evaluate that.
This is Felisa. I'm for moving, I guess, this language to another part of the application. It could be at the beginning. Also, I didn't want to lose sight of, I guess, an issue Christina or other board members have brought up about maybe revisiting the question about the language or the intent, the legislative intent of the council when they wrote this language. Is that a question that can be some further research that can be done? Because I think this is going to pop up again. I don't think we're going to solve this here in this meeting. So I don't want to lose sight of that question, which is separate from, I guess, placement, and also what the standard we're going to use if we run into this question, if an applicant does claim actual innocence. So those are my 2 cents.
Yeah, I think it is worth raising with the council. I already have a pending letter that I hope to get out today about the board, adding a board member. So it's sort of, Antonio, I see you here, and I want to give you a moment to have a voice. I also want to recognize that you've been with us for 23 minutes, and that puts you in somewhat of a disadvantaged situation. But please, any comments you have, we would welcome.
Yeah, since I obviously did not work on this piece of legislation, it's hard for me to really comment and say what the council was really thinking. I would have to do a little bit more research on my end and probably talk to Kate and Sonia individually to see so we can iron these sort of issues out.
Okay, so I may go ahead and draft some language that would be formulated into a letter making that request of you.
Yeah, absolutely. That would work.
Okay. Yeah, so Felicia, that was a great point, and we won't let that part drop. I am concerned about, let's get this application moving. I want to do it right. There's kind of a thought on the floor that we take this out of one of the priority groups and put it up early in the application. Will there be other cascading effects of doing that?
I think if it goes, Patrick, respectfully, this is Betsy. If it goes way up to the top, parallel to pardons or commutations, then it suggests that we are writing a letter in support of an actual innocence finding, and we don't have that capacity. So I think it should really just come in later, but as something they can talk about either in their essay or I think it's in their essay, because I didn't see it as quite a priority group when I read the statute. But I was curious about the saying not to put in any facts about their claim of actual innocence, because if they've already exhausted all their judicial remedies, what do they have to lose by telling us, hey, I raised this claim of actual innocence in the court, but let me tell you, the court didn't buy it, that this, dead guy did it or something, but he really did. Like, why can't they tell us the facts if they've already exhausted all their remedies?
I think it's hard for people to know whether they have truly exhausted or not. Is one issue, particularly if they're filing, under other court rules for like a new trial or under 23-110. I think it's hard to know if you're a pro se applicant whether you have really exhausted other remedies without talking to a lawyer. It's sort of it's easier on some of the like compassionate release if you've been denied compassionate release, or if you've been denied IRA, that you can apply again for IRA. So I don't know at what point you've exhausted that, if you can reapply in 3 years. But I think that's one reason.
I think another reason, I completely agree with you, Katja. I also think, Betsy, while you raise a really good point, I would argue in the interest of just making the application as streamlined as possible. And the more we get into these sort of like trees of if yes, then blah, 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 if no, then blah, it just makes it really complicated. And I continue to think that the facts just aren't, those sorts of facts are unlikely to be terribly relevant to us. If the person, there may be a very unusual circumstance where the person has exhausted and lost all of their claims, and yet we want to know why they think they're actually innocent. But I think in most cases, whether or not they continue to claim they didn't commit the crime is not going to be terribly relevant to us in determining whether or not we want to grant clemency. Or recommend clemency, I should say.
Okay. Then I guess I'll just leave it at, I'd rather not have it be a third category like pardon, commute, actual innocence. I'd rather have you're innocent, I was innocent come in the essay question about, why they're not remorseful because I didn't do it.
I think that's a fine way to go. Would coupling that with when we describe, when we ask other questions on background of court cases, when you did this, should we include a reference there to petition for innocence or whatever the legal term is for it, court case number, da da da? Should we call it out there in those little descriptors in the earlier questions? I mean, that way we're prompting them that, this is a thing, this is part of your attempt to exhaust all of the remedies.
I think that's a good idea.
I agree.
Okay. have
Okay,
it
so
added. So the decision is to remove it as one of the priority groups and add a question about whether or not their case is based on innocence and to give us the case number and so forth. So,
Yeah, that's fine with me, as Andy speaking.
okay. So,
I really would love to hear it from all board members on that issue, though. Is that consistent with where we as a board want to go?
Well, I would say I'm not a lawyer and I don't play one on TV, but I like that. I'm Patrick.
This is
Thank
Lisa. Yeah, I think it makes sense. The prompting, the least, I think it's good to like at least mention it on the application. We have to figure out a way to say you don't have to. I guess the standard. Uh, I agree with where the placement and the prompting. It's just like figuring out the whether or not you want to go into the facts or not.
Mhm.
That's the standard by which you don't want the person to necessarily get themselves into trouble, or we don't want the board to confuse itself by trying to say they can do something which they cannot, which is what I'm hearing, being a trier of fact, because we are not. But I agree with what you're trying to do here, Patrick. Yeah.
Okay, so on the screen, Christina's brought us to questions 8 and 9, and
so question 8 and 9 just asked about whether they're challenging their conviction, or question 8 asks about whether they're challenging a currently challenging a conviction or sentence, and then 9 asks whether they've exhausted their judicial remedies. And I think just to kind of hone on, because we seem to be narrowing down, we can put it, either after pending cases or before all of this. Are you basing your application today on a claim of innocence? If yes, please give us the case number and the case number that's connected to it. And then if no, continue to the next question, just something simple. Thoughts on that?
Sorry, my understanding this was going to be kind of part of the exhaustion question, kind of like here are some other avenues that you might want to think about.
As in collapsing it into 9 is what you're stating, Ilana?
Yeah, I think so.
I think it makes more sense there as well. Sorry, this is Katya.
Thanks, Scott. Okay. Okay. Well, how does if they've exhausted all of their judicial remedies? If it's yes, please tell us more about the relief you've sought in the past. See, that's where I guess it goes into the possibility of asking for more. I really think it should, I'm happy for it to fall within this range, but I think it should come after the judicial exhaustion of remedies, so we know that they think that they exhausted all of their remedies with respect to their challenge. And then just ask after that, is your case a case that's based on innocence? So I would possibly recommend putting it after question 9.
So I think the point is that a motion for actual innocence is one of the judicial relief mechanisms available. So it's just kind of a different, it's not a challenge to the sentence. Obviously, it's a challenge to the underlying conviction.
Right.
But I think it would just kind of be another example here that we would include. I think you might draw extra attention to it by having it be a separate question. It probably is relevant to only a very small subset of people. And just kind of list it as an example of other relief.
Well, if that's the case, certainly we can add it in here. If this is, this can include motions for compassionate relief, a relief under the Incarceration Reduction Amendment Act, and, claims for innocence. And then if it says under yes, if you are, please tell us more. I guess it would say, please give us the case number that involves a relief you've sought. I think we
It'll
would,
still be in the same case number. It'll just kind of be a post conviction part of the docket. Right? Am I wrong? Anyone?
So in this sentence, you'd be putting including relief such as motions for compassionate release / innocence,
New trial.
new
Say
trial.
on grounds of innocence.
I'll put the link to the statutory reference for this in the chat.
relief. I guess we could say this can include motions for release or a relief under the Incarceration Act, and motions that are based on innocence, or a motion for a new trial based on innocence. But I'm sure there are other ways that you can challenge a conviction based on innocence. Is it on? I guess is a new trial the only method?
So DC Code 224135 is a motion to vacate a conviction or grant a new trial on the ground of actual innocence. And I think that's kind of where the judicial remedies for actual innocence would mostly be housed and litigated.
Let me know what you think about this over there. If yes, please, instead of saying please tell us more about the relief you sought in the past, please tell us the case numbers. Please list the case numbers, date of relief you've sought in the past.
So it should be the same case number as their case of conviction. It wouldn't be a new case number. It would just be like additional docket filings in that same case. The date could be relevant.
Okay.
But maybe any decision, I don't know. They might have a hard time summarizing a decision, but
Please tell us the date of filing of these challenges, or please tell us the date of when you made these challenges.
We're going to have all of it. This is the case for which they are seeking relief. So this case is probably the easiest one to get, right? Because we're going to be able to get their court file, and they will have filed this in the court file. So it seems like an unnecessary burden for people to have to say when we're like, the first thing we're going to do probably is get the court docket in the case.
Right. I guess the question is, well, how much, if they do have these, do we even need to ask for a prompt for more information about any motions or challenges that they've made if we're able to receive their entire docket?
you could just say, like, please tell us what motions you have filed and what the judge decided. That the second part is more optional, but could be a helpful
I'm trying to find wording that motion, that's a legal term. So I was trying to find wording that please tell us how you challenged your conviction or sentence.
I think it's just going to all be there.
Yeah.
It's going to be like, sometimes people write letters and then the judge says, they file the letter in the court file, and then they say, I'm treating this as a, this kind of motion and I'm deciding it this way. And so sometimes the person writing in wouldn't even know whether that's a motion or how the letter is treated by the court. So I think where we can really just go right to the docket, we should just do that.
Okay.
And it's not really confusing. It's like the docket will have every single entry of motions inputted by parties, the individual, defense, prosecution, all the orders from the court, especially for the cases that are newer. It's really easily accessible.
Okay, well, what if we just said, please continue to the next question? Part of the reason why we even had these tell us more is just for in aiding the board in processing these applications, so we can, even if we get a little tidbits of that, information here and there that an applicant would know about their case, then we can corroborate it with a docket or a court filing. So for instance, part of the reason why I think the date might be important, please tell us when you made these challenges. They're like, well, in 2001, I challenged my sentence. In 2000, just something pretty bare bones, so that we're like, okay, they're really talking about this, or just to be able to have some more information that the applicant can provide, but I can also understand how they may not have that. So it's totally the board's decision. We can just keep it as a yes and then remove the lines, or we could just ask for more.
Yeah, I mean, somebody's going to have to review the record anyway, right? So asking for them to specify where in the record, I don't know how much that gets us actually.
Okay. All right. So with that, if the board's okay with this, I can continue on.
Let me just ask one more. Have we addressed the matter of innocence sufficiently for our discussions or for our deliberations in the future? And I suspect the answer to that's probably.
Okay. Thank you all. All right. I believe
You're taking out the reference to it in the.
It has been taken out as a
Okay.
priority group. Yeah.
Thank you.
Yeah. So it's no longer listed. Yep. And then we just have an other category, just they might have the other category is for cases that they are seeking clemency for that are not within the board's priority group. We will consider those. So it's keeping the board open to other issues that may come up that were not necessarily delineated in the statute. All right, so demographic information just goes to reporting based on the regulations. On a yearly basis, the Clemency Board will provide a report on applications it receives. So gathering information on gender, race, and then this goes to the essay question. So because of this, I guess we'd have to make a little bit of a change to maybe we make a note that, if your claim is on actual innocence, please don't write an essay question, because our essay question goes into remorse, rehabilitation, and all of those issues. So another issue to probably rephrase or provide some guidance to an applicant to not do this if their claim is based on actual innocence, but defer to the board on this. So the essay question asks, below, please briefly describe why you should be granted clemency. In your response, please provide information about your connection to the community and how receiving clemency would improve your life and contribute to the community. Explain why you are no longer a danger to society, and discuss your efforts at rehabilitation and your vision or plans if you're released. You are released. 3, include information about your personal growth, development, community service, educational advancements, or feelings of remorse since your conviction. Helpful tip, please be as detailed as possible about yourself and your case. If you need more space, you may complete your answer on a separate sheet of paper and attach it. So with our discussion on actual innocence, I would certainly say here as a note, if your claim, your basis for clemency is on innocence, please do not provide a response to this essay question. Would be some sort of an instruction we can provide.
I know I had mentioned before that we should kind of list that explicitly, but I think actually thinking about it more, perhaps this should just be silent on it. You know, why should you be granted clemency is a pretty broad category, and I think somebody could certainly put in whatever information they deemed relevant to that. I mean, if they just say I'm innocent, full stop, you know, I don't know if that helps the board with all these other questions that might be relevant to the clemency question. I think it might just be best to be silent on it and just kind of include all of this, and then it doesn't specifically prompt that answer.
Yeah, I agree. And then somebody could talk about their connections to their family and all the classes they took in prison and everything else that might be useful to the board. So,
Well, what about sub 2? Explain why you're no longer a danger to society and discuss your efforts at rehabilitation and your vision plans if you are released. It's the no longer a danger to society efforts at rehabilitation. I mean,
And feelings of remorse.
Yeah.
You could rephrase it as explain why you are not a danger to society, just in the current tense or present tense.
Oh. The answer to that could be I'm innocent of this crime.
Mm-hmm.
Mm-hmm.
good idea.
That's good.
And again, I just want to clarify that we are answering this question as, you know, individuals who are, some of us attorneys, some of us very educated. And so, again, not everybody will have an attorney helping them with this application. So my concerns is, what are we receiving on this piece of paper? That could be, you know, incriminating. An applicant's not thinking like, oh, I probably don't want to add facts of my case on here because I don't want this to be a legal document that will be used against me in any appeals that I can later seek. So I see concern with it, with the broadness of the question, and no further instruction on, but again, we go into providing some legal advice here, and this is where I think it gets into a sticky issue with actual innocence cases.
So I have an additional concern, and this whole time I've been trying to think about how to articulate this, so apologize if I'm inartful, that I am worried about asking about actual innocence. And I know that's not the term we'll use, but for the purposes of this conversation, asking if somebody is innocent or if they're claiming innocence is going to cause a lot of confusion among people who do not have actual innocence claims and aren't planning to bring an actual innocence claim, right? Some who just might, right? Like there's lots of reasons. Innocence is a strong word, right? Like there's lots of people who think they shouldn't have been convicted, or it wasn't fair, or that they were guilty of some of the things they were accused of, but not all of them. And the reality of it is, to me, the purpose of this is to tell people you don't have to express remorse if you didn't commit the crime, and that is not going to be a basis upon which we reject your clemency application. But from my experience about being a public defender, right, people sometimes think that their lawyers care more about whether or not they're actually innocent than if they are, right? I'm worried that people applying for this are going to think they're not going to help me if they think I committed this crime, or that whether or not my views on my conviction are going to weigh into this application in some way. And I know that I'm not explaining this articulately, but for the most part, right, if what this purpose of the statute means is that the clemency board should not reject applications just because somebody's innocent, that's fine. I don't want to get into a back and forth with somebody about whether or not they think they've committed the crime, because for the most part, in most cases, it's not going to be relevant to our analysis. And I'm worried it's going to cause people to provide a whole lot of information or to think they need to answer the question about whether or not it's going to like cause this like Sturm und Drang about how they want to answer the question about whether or not they're innocent. And I'm just not sure what we would do with the information anyway. So that is why I'm sort of leaning towards not even getting into this, but I'd be interested in other people's views.
I agree.
Well, I appreciate the passion of your comments, and I think I get it. I've said before, I think the basis of the application is critical. I would like to know if they're claiming they didn't do it and some other dude did it. The first step in any rehabilitation or reform is acceptance of responsibility. And if we've got somebody who says, I didn't do it, but I've reformed, I think we need to take that into consideration. I think we're going to face tough issues about how far we look at the facts of the crime. But if we don't want to retry it, but if the evidence was that the person was caught red-handed on videotape doing it and confessed, and now claims I'm reformed, but I didn't do it, I think that's something we just have to know.
Andy, thank you. I agree. The only issue there is, and that's exactly the problem, is that if you didn't do it, you have nothing to be reformed from.
I think the question, though, for us is, does this belong anywhere? And what I struggle with, Emily, like I agree with you that it's confusing. It like opens up more than needs to be opened up. Is this exhaustion question, which is a criteria under the statute that you cannot apply if you have other remedies to exhaust, which is why I think like putting it there in the exhaustion section, right? Because it says no application for clemency recommendation shall be filed pursuant to this chapter if other forms of judicial or administrative relief are available based on existing law and already discovered evidence. So then you can, like, maybe you were innocent, but there's not the evidence that you would need for the claim. And so maybe that's something that is developed later down the road. But as an initial question for the application, it's really on this eligibility grounds.
Right. And just to give, I'm not suggesting necessarily even a particularly approach here, because I agree with you, Andy. I think it was you who raised the points. I'm just not sure how to handle it, right? And to just give an example, right? What if the person was convicted of homicide and they had a self-defense claim and the jury rejected their self-defense claim, right? The person isn't claiming they didn't shoot the person or whatever. They just continue to feel like their fear was reasonable and the jury rejected that. And I think somebody like that might have a hard time deciding how to answer the question. Or if somebody thinks they should have been convicted of second-degree murder instead of first-degree murder, right? I just think it is to ask somebody, are you innocent of the crime for which you committed, is a more complicated question, I think, than it might initially appear. But I do understand the idea of it being relevant to this board, having some information about whether or not the person, just to saying, I didn't do this.
And not to repeat, I think I might have said this earlier, but I think the basic question, why should you be granted clemency, would allow someone to say, it wasn't me. I don't think that it precludes that response if that's the answer for why they believe that they merit clemency, but it isn't a specific prompt either.
But I don't think that they're isolated. January 6th. I think that.
Thank you very much. I agree with your answer there.
Gentleman's time has expired. Thank you. Now please to recognize the gentlelady.
Um,
I think we're hearing some other conversation.
yeah, oh, there we go. Okay, so is it my understanding that the board thinks that leaving the question, please briefly describe why you should be granted clemency, and getting more information about their basis for innocence, that should suffice, and no concerns with the additional questions that follow, because they may say they can have legitimate responses to that wouldn't implicate them later on.
Christina, I'm not going to go along with that. I would ask for a vote on that question if that's where you think the consensus of the board is.
Well, that
Actually-
would leave it as is what, that's the way the question is right now.
Okay, take out longer there, if you would, in the question.
Oh, leaving it as is. I'm sorry, I misunderstood. I thought you meant taking it out and not putting it anywhere else. My apologies.
No, that's okay.
Okay, so we're reading this question and determining whether the board feels this is sufficient. Is that correct?
Correct.
Okay, so let's take a moment to read it and then I'd like to hear each member of the board. Okay. Any comments about the essay question and the criteria that we leave in there? Any concerns about it?
I would suggest taking out feelings of remorse. If we read that part of the statute as this, here's what we consider actual people who are innocent, people who are guilty. It's all sort of, no one is excluded from consideration, which is how I read that section of the statute. I would also say, for example, in response, please provide, for example, one, information about your connection to the community. What if somebody who has been detained for a really long time and does not have a connection to the community, right? So I just think it should be, for example, that this is an inclusive and not, for example, in your response, please provide 1, 2, 3, and then I would suggest deleting feelings of remorse, because I think that could be part of rehabilitation. Number 3, include information about your personal growth, development, rehabilitation, community service, educational advancements, or other information you feel is important.
And I think that keeping feelings of remorse as a possibility is helpful. I agree that it shouldn't be and, but I think keeping it in as the or is a helpful part of it. I think you don't have to say your feelings of remorse, but I think if you do have genuine feelings of remorse, then that type of narrative response would be relevant.
I'd also like to take out helpful tip, because I don't like be as detailed as possible about your case. I don't like that. That may or may not be helpful. And it also just may cause people to spend a lot of time on, like, if they took a plea, I think the language, maybe they just want to go on the language that was part of the factual proffer. It just doesn't, it's not necessarily helpful or necessary, and it could be burdensome. So if it's just open-ended, like, here's the stuff that you know, giving people some guidance about what's important, but not telling them about to be as detailed as possible about your case.
That makes sense. We might also want to take out in the very beginning below, please briefly describe. Maybe we should take out the word briefly. I mean, this is really their chance to, this is the advocacy piece. So I think it could be brief, certainly, but you know, I think any advocacy they want to put in this now is kind of the time for that initial advocacy.
Right now, let me just add my 2 cents. I think what we have right now is fine. Being that we you all of you are highly educated, I think you're going to overthink this and think the people that we're trying to help right out of it. Because even if you said briefly describe before the essay part, it says if you need more space. Well, they know they need more space. So let's count on a little bit of their intelligence. They'll know what to do. So we can stop right here. We're just going to be beating this horse left and right. Now, if you want to keep talking about it, let's keep talking about it. But I think it's done. Okay.
Yeah, I appreciate that. Going back to the basics here, I just want to make sure we're doing what the law requires.
Okay. If there are no more questions, I will move forward. Okay, so this just provides a little more space. And then this gets towards the end of the application, which asks an applicant to attach any information which may be helpful for the Clemency Board when reviewing your application for a letter of recommendation, such as supporting and background documentation about your conviction or convictions, rehabilitation, and or remorse. I guess we could just, so it says that for applicants that are currently pending clemency applications with the DOJ, please include a copy of that application as an attachment if you have a copy. So this is just basically to obtain any records that they may have with them that concerns their application. Any questions about that ask? And then,
Christina, should we
yeah.
say that any records you provide will not be returned to you to indicate they should keep their own copy and not give us the only one they have?
Sure, yep, I think that's great. Any records you provide will not be returned. I guess we could also say, please only provide copies of your records so they can maintain.
That gets at the same thing.
Okay,
Thank you.
sure, thank you.
And I might be getting a little petty about this, but I think it was better the other way, because if you say please provide copies, these guys might just have copies and they will give you all their copies, which would be really their originals.
Mm-hmm.
You understand what I'm saying? Because I've seen them do that before. They wanted copies. I gave them the copies, but they didn't have their originals. The copies were their originals.
I see. Good point, too.
That's a good point. Any record? Any records so please make I guess I was just gonna say, does this suffice or an instruction further of please retain copies of your records?
That suffices for me.
Mm-hmm.
Because if they have copies, they will make copies of the copies.
Okay. provide to. Okay, anyone else? Otherwise, I'll move forward to the releases. Okay. So the release forms, pretty standard. We have release forms to obtain those records from BOP. And those records include progress reports, disciplinary records, education records while incarcerated. And we provided links and how we will provide further instructions about how to fill it out. And so we've done that here, where they should, the address of the clemency board, where they should initial. And then there's also a separate release for BOP for medical information. And then we have a release that we drafted in negotiation with CSOSA. That's a standard release that they have approved. And it details what records they would obtain from CSOSA. And the next is a standard release from the DOJ, and that's if they have a DOJ application. So that's why in the beginning we asked if they have a DOJ application that they've submitted. We can obtain, in case they don't have a copy of their DOJ application, we can obtain copies of that application through DOJ. And then this is what we're currently working on. We added it in here so the board's aware. We're working on getting background checks conducted through MPD, and we're building on that release for that. And then there are additional documents here that we would need to obtain from the court. And so we are going to work on building those 2 documents, and once we have those releases, they will be added on to as a hyperlink onto the website so applicants can have access to them. And these are all the releases we currently think we would need to process an application. Any questions?
I had a question about the Superior Court documents. I'm not sure if this needs to be included in the application, but I think there are a few other ones that would be relevant, but this might not be relevant for purposes of the application.
Okay. It would be great if you could send us those, Ilana.
Yeah. So I think I know I've noted before, I think the plea and trial transcripts, I don't have a problem with it, but it might just be really voluminous and extensive and expensive. But the sentencing transcript might be a more relevant and possibly even shorter transcript for the board to have. But I also think that some other documents about what actually happened in the case, there could be other things that are a bit more probative instead of just the sentence and kind of the initial charge, which probably won't actually talk about the facts, like either the Gerstein affidavit or arrest warrant that's initially filed at the time of charging, or the plea paperwork and a proffer of facts in support of the guilty plea, which kind of states what facts they plead to, and maybe any sentencing memoranda submitted by either the government or the defense. So those are just some ideas of kind of more other documents that Superior Court would have that could provide a broader picture of the offense that was actually committed.
Other political protesters, including those similar.
They don't need a release form, right? Is that what you were saying too, Alana? So it just.
Yeah, I don't think that they would need a release form. They should all be public documents. I mean, I guess something could be under seal, and I'm not sure how that would work. That could probably be a special consideration that could be handled as needed. But yeah, I agree. They're probably all public documents.
And there's no standard release form. I wonder if your office is providing this, would you require anything, or you would just turn over?
If it's a public document, I mean, public documents, I think are public documents. But I don't know if Superior Court, if you've had a conversation with Superior Court about what forms, have they said they needed a form?
Well, we haven't had that discussion. We divided this up, Ilana, based on recommendations you sent over. So we don't know whether, so similar to CSOSA, we drafted the release with them because they didn't have a standard release like BOP or DOJ. So we would, once we have that conversation with the Superior Court, we'd know more.
That makes sense.
Yeah.
I think the plea and the trial transcripts are almost never, the trial transcripts could be with the Court of Appeals, but the plea and sentencing transcripts are not going to be filed with the court unless some party, like the government or the defense, attached it to a pleading for some reason later. So that's an instance where maybe Alana, your office would have it and they would want to get it from your office, and it's a public record, but it's not a public document. And I don't know if there's a separate, USAODC form that needs to be filled out or what, or how. It's just something to think about how that is handled.
I don't know about any privacy concerns with those, but I also don't know if any court reporters might weigh into this. I know they sometimes have thoughts about them being released more broadly, but I don't know. It's kind of the bottom line.
Is there any way, Ilana, could you look into that for us and see if possibly we could obtain those from your office?
So it's not something that we have in every case as a matter of course. There might be cases where we might request them, but it's not like something that we just have in every case. And I am worried about kind of committing us to providing those.
Right.
I don't know. Like I said, we might not have them in every case. And I don't know if the Court Reporters or Court Reporters Association would, typically when like the government and defense want them, we kind of each order our own copies and it's kind of paid for separately. And there's a lot of kind of payment caveats.
Understand. I guess we'll have to figure out more how the Clemency Board can get that information and how much it costs if there isn't one already on file, and we may need to have one produced. And that's something we definitely have to look into then. I'm happy to do it.
Christina, can we move on to another records point?
Sure.
On the request for BOP records, we might want to amend it to specifically request a copy of BOP's pattern evaluation, which under the First Step Act since 2018, when it passed, BOP is required for every inmate to develop a rehabilitation assessment and treatment plan. That sort of says what they think of the defendant's abilities to rehabilitate. So that's something we might want to look at.
And you said it's called the pattern assessment?
It's called pattern. I don't think there's an E in it. It's an acronym for a long list of things. But if you spelled out the word in caps, they would certainly know what we mean.
Okay. I'm happy to reach out to the GC and ask him about that, and whether when we make this ask, does it include the pattern records or not?
Okay, that'll work. Thank you.
Sure. Okay. Well, that brings us to the end of the application. I wanted to open the floor to the public. I see Professor Lloyd had to just drop off. She just sent a message in, and move from there. So let's do this list. So on the list we have Ethan Anderson. Any questions that you may have?
No questions at this point.
Thank you. Professor Ross, any questions?
Yes, let's see. The first one I have is the issue that the subgroup decided not to include all that information that was designed for somebody to put their best foot forward. I think it's about 4 pages in the draft application that dropped out. such as education, information under rehabilitation, such as, letters from people, things like that. So it's at the applications that we sent to all the members of the subcommittee for each, the pardon and the commutation, it included lots of sub information. So what I'm wondering is, maybe what the decision was not to do that and whether, but more about moving forward. Should there be something that we can put in or you can put in to the website that says if you want some help in filling out an application, take a look at XYZ, and we could post these probably on like the CCE website where we give instructions to people who are trying to argue for commutation so that they're putting their best foot forward, and for pardon so that they can know what it is they want to fill out, such as, the education, how has this affected their ability, how for pardon, how has this affected their ability to move on with their life, things like that, that people, won't know about. So we, the clinic could create something like that. And then as long as there's something that doesn't have to be in the application itself, but somewhere on the website that has been created by the mayor's office, it has some kind of link. And then we could put some of that information about innocence in there, because I think that this was an amazing discussion about innocence, by the way. I learned as much from all of you as you got from our initial draft. But the idea that if they want to talk, if they want to write something and they think they're innocent, they are in a much better position if they get help from a lawyer. I understand that you feel like you can't say anything like that, but we could. So is there some kind of ability for us to supplement what is really a very, very bare bones and not very accessible application process for somebody who has a, low education level and won't know that he could get a letter of recommendation or talk about his education experience, or, all the things that we included in our initial draft.
So just to answer your first question, the decision not to include all of that specific information was really to try and look at, we already have an application that is dramatically long. We don't exclude folks from adding that information. And in fact, the essay would allow, we tried to write the essay question as broadly as possible for people to bring their information in. I would also say, on the second matter about we're a board that is charged with evaluating whether or not to do this, and are sort of walking this fine line between being an advocate for somebody and someone a body that must make a decision on information presented. That being said, I'm open to figuring out a way to point people to resources that could help them. Absolutely. And I think I've heard other board members express that, and am absolutely willing to do that, Professor.
Thank you.
The bare bones nature of it, I take a little umbrage at as if we're not trying to get people to really be able to state their full case. It's in fact the exact opposite. We don't want to make this thing 26 pages long, because that's daunting. It's already daunting, and it was trying to be parsimonious about what we actually asked for, but leave tons of room for people to do it themselves.
And if I may interject on putting it on the website, and certainly that's definitely feasible, Professor Ross. And one of the things we have is an outreach committee that is on the board, and our next steps would be considering how to, provide resources, helpful links and possibly it may not come from the board, but on their website, if you need help, here are some resources.
Thank you.
Any other questions for Professor Ross?
Oh, no, I'll mute myself.
Thank you, Professor Ross. Simone Smith, any questions?
Hi, yes, I'm Simone Smith, and I'm with Howard University School of Law in the Reentry Clinic. And I just had a couple different questions. My first question is that I know that there were parts of the application that in green, I think referenced that it just applied either to the pardon part of the application or the commutation aspect, but it didn't apply if you're applying for like for pardon, then you might not need to fill out some of the information in the other areas. So my question is there a way that we could indicate on the application to disregard if you're not applying for a pardon or if you're not applying for a commutation, just to indicate in those areas? And then my only other question was regarding, and this was addressed actually at the last meeting, that the DOJ application may say that the applicant is not eligible, and just like indicating to them to note that they are eligible. It's just that the language on that DOJ application that we will be, kind of prompting them to before they start this application, just to have that information going into that process.
Thanks very much for your comments. The green text that you see in the application as Christina presented it is really for our technology friends to force that question to be asked. And so it's not going to be in the text that they would see. It's just, it's a method that would force people to respond to that question. So I don't know if that clarifies that part of your question. As to the second, I'm not really sure. I haven't closely studied what the pardon application does, and maybe other members of the board would have a response for that.
Yeah, I was not entirely sure what you meant with your second question, Simone. If you could clarify, that'd be great.
Yeah, so it's my understanding that when somebody goes to apply for the DOJ application, it will say on there that they are ineligible, depending on where they had received their conviction. And so it was just that my understanding is that the DOJ application doesn't specify that they actually can fill out that application, and that was something that was going to be addressed on this form when they're kind of going down the checklist, figuring out if they've used all of they've exhausted all of their remedies.
If I can jump in, I think it was brought up at an earlier meeting where one of the board members said they went to the DOJ list, and it says, have you been convicted of a federal crime in federal court? If not, this doesn't apply. This is only for federal convictions. I mean, it says that in a couple of places. So I think it's just hard to articulate, well, how is it wrong? It's wrong in a lot of places, but we know that people who are been convicted in DC Superior Court often don't fill out that application because it says it doesn't apply to them. So what I understand, Simone, to be asking is there a way to actually put it into your application that regardless of whether it says only for federal, that yes, you can fill out the DOJ application form. Simone, is that what you were saying?
Right.
Yes, that's right.
Got it. Okay, so again, that goes into providing legal advice and advising them on an application that we don't control. It is the DOJ application. However, one thing that, because of that issue and the fact that, the DOJ application is not DC centric or factors in the district, and we were aware of that in drafting this application. This is why we don't require that prerequisite that they have a DOJ application to even receive a letter recommendation from us. So ultimately, whether they applied for clemency with DOJ or not, they still are able to apply and receive assistance from us in some sort of way if they're eligible. So that's one of the ways we can ultimately resolve that issue. Does that satisfy your question, Simone and Professor Ross?
Let's say yes, because she somehow is offline, and and if she comes back on, we can ask her again. But thank you very much. Oh, there you are. Simone, they just said, "Is this satisfy you?" I don't know if you were able to hear the answer.
Yeah, sorry, I'm having computer issues, so I'm disconnecting as you see. But thank you. Yes, I caught the end of that, so thank you.
Okay, great. Thank you. Okay, I think that is all public members that are currently still on the call. So we've just turn it over to you, Patrick, and I'll stop sharing the screen. Thank you, everyone, for all your help with this.
Thank you. So I'm going to ask the board if are we ready to go ahead and approve this application, noting the one minor change that we regarding the DC Superior Court and the MPD.
I'll just note that I sent a few kind of typographical changes. I don't think there's anything substantive to Christina. I tried to address all the substantive things here, but I just sent a few kind of more typos things.
Thank you for that. Appreciate that. So are we ready to approve the application? And if so, would a board member want to make a recommendation that we do so?
Patrick, I move that we approve the application if all the board members are ready to vote, or however you want to do it.
Thank you. Is there a second?
I second that, Patrick.
Okay. All those in favor of approving the application?
Aye.
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 Those are 3,000 people.
4,
Aye.
5.
So I do think
It's Felisa. Can I object? Because I don't know if I'm ready. So I'm going to put an objection.
Well, you can vote no. Okay, so I said
Put
those
that
who
down.
in favor. I have how many now? I think 6.
Can I, Patrick, I don't mean to throw a wrench in the works. I know I already voted aye. I wonder if it makes sense to just send it around one more time so we can all look at the final version of it. And I don't know if voting online is permissible. I don't know the rules of order here, but I would love to just see the final again and then vote.
Okay, somebody who knows parliamentary procedure, and I'm sure some of you love it and had courses of it in law school. And tell me what I do now, because we're in the middle of a vote. We have 6 who approved. One's now pulling that back.
She would have to amend the motion.
I
think
We're supposed to
heard
have
that
votes in
the,
public
She would have
meetings.
to amend the motion,
Yeah.
but she's asking for that.
I hear the council say all the time with, what is the language, Antonio? It's like with conforming and, I mean, if
Yeah.
our concern is typos, and I think there's always like concern of like, let's just like, they're tiny things that might be a little bit off. What is it with conforming amendments?
Conforming and technical
With leave
amendments is
to
fine.
make-
With leave to make.
to amend with technical and conforming amendments.
Yeah.
Exactly, because I think that's where unless I'm misreading you, Emily, I think that's where the issues lie. Like we have the big stuff done, but just there might be a little bit of technical
Yeah.
stuff in the margins.
Yeah, you
That's
could
right.
make
If
a
I'm
friendly
allowed to
amendment.
amend my vote, I will amend it to say what Antonio just said.
Me too. Okay, so as so amended, those in favor?
Aye.
1, 2, 3,
Aye.
4, 5. Okay, that's 5 in favor, 6 in favor, and those opposed. Any opposition?
Abstain for the record.
Yeah, of course, duly noted. I'm trying to make space here if somebody wants to oppose.
Felisa,
Felisa is with, like, I guess with the amendments and objections. I want to see it one more time.
Okay,
What am I agreeing to?
got it. So given that, can we now decide that we're going to circulate it one more time and have a final vote at the next meeting? Is that what we're really saying here? Or have we had a final vote?
That's what I heard.
I'm looking to my counsel here to tell me.
well, Felisa objects, but we can certainly vote on it. I'm happy to recirculate and then we can vote on it another time.
I thought that the sense was to vote now to approve with conforming and technical amendments. So that
Correct.
you don't, because you can't vote by email under the Open Meetings Act.
Right.
Okay.
I think Felisa objected to that, from what I understand.
Yeah, so you
Well-
have one dissent.
Right, so you have 6 in favor, 1 dissent. So the vote's been taken, the application has been approved with the caveat that Antonio so adeptly gave us, and we'll go forward from there. Okay, so Christina, I'm assuming that you will circulate this application so everybody gets to take a look at it. If there are conforming amendments that we need to make, those will be made, and then we will have those for the next meeting. Is that correct?
Correct. And if anyone else on the board has edits they would like to make or typos that they've noticed, please send those. I think Katya, you mentioned you had a couple as well. So please send them to me so I can send a clean version to the board.
Okay, great. So just a little bit more board business. I do want us to start thinking forward, looking forward to what happens now that we have an application that is substantially complete. I know that there is some internal work to do for the board staff director in terms of getting this on the website and getting that up in both a form that can be filled out on a computer and a form that can be downloaded and printed and filled out by hand. And then I also know there are probably some administrative procedural things that the OGC needs to do. And I know there were conversations that still need to be had with MPD. Notwithstanding all those, we'd like to get a go live very soon. And I'm not going to say a date, but we're really pushing that this goes live and up on the website very soon. And, you know, consistent with that, I also think this is the time for us to start to consider a really serious outreach push to educate the public on the Clemency Board and this option for those who are eligible. And so I hope to have conversations with several of you privately between now and then, just to talk about your availability, interest to participate in those between when we go next. I would also note that I believe that there were staff who were included in the district's budget this year for this purpose too. So appreciate that we will be having more help in OGC going forward on that. So just noting that as well. What I was hoping to do is if we could get all of those kind of administrative things done within the next 4 weeks or so, that the board could meet on Friday, February 18th. That gives OGC a bit of time to get some of those things matters handled. We'll get all those amendments in. And really, I'm also looking to change the time of our typical meetings to be Friday afternoons. I have a new standing conflict on Friday mornings that makes this difficult for me. And so I was wondering if we could plan on Friday, February 18th at 1 p.m. For our next meeting.
That's fine with me, Patrick.
I have a conflict on the 18th. We are in the middle of performance oversight season, so we have a hearing scheduled for that afternoon. So for me, I would be unavailable.
Okay, but there's not you don't have a standing conflict with that going forward, right?
No, just the 18th, yeah.
Okay, thank you. Anybody else unable to participate on Friday, February 18th at 1 p.m.? Fantastic. So we will go with that. Really appreciate everybody sticking with us. This is a bit longer than we had anticipated. An amazing conversation, and I'm so glad we had it in a public forum. So thank you all very much for that. Really, really appreciate it. And thank you to Christina and other members of the OGC staff for fantastic staff work in the background, tracking all of this. So thank you very much, everybody.
Okay, same here. Thanks, everyone.
Thank you, everyone. Have a good one.
Thanks, everybody.